Assalamualaikum and good morning everyone. My name is Muhammad Jamul Izzuddin bin Jamaluddin. My matric number is 305055. Today I will present a case involving the National Union of Transport Equipment and Allied Industry Workers. In this case, 5 union members were dismissed in 2016 after attending a peaceful union briefing outside working hours and off company premise. The union staged a protest outside EPF headquarters in Shah Alam demanding reinstatement with full compensation and urging EPF to divest from the company until justice was served. On 6 February 2025, 15 union members, including one of the dismissed employees, hand over a memorandum to EPF representative. The union claimed the dismissal violated Malaysian labour laws and EPF worker well-being policy, which protect freedom of association. They filed a case under Section 59 of the Industrial Relations Act 1967, which prohibits discrimination against union activities. With advice from the International Labour Organization, they urged the Industrial Relations Department to prosecute the employer for union busting. However, the case remained unresolved and 5 workers are still unemployed. The dispute was brought to court because the dismissal were alleged to be without just cause or excuse, violating the employer's right to freedom of association. The union urged that the employer breach both Malaysian labour laws and EPF working well-being policy. Despite filing the case more than a year ago, no resolution has been reached, which led to the public protest in 2025. This highlights the long-term impact of unfair dismissal and weak enforcement.
Morning. My presentation will focus on the legal framework of the case, analyzing the core issue and predicting how the court might rule. I will cover the parties involved, break down the 4 primary legal violations alleged, and explain the critical factor that will determine the final judgment. To understand this case, we must first identify who is involved. On one side, we have the claimants, the National Union of Transport Equipment and Allied Industry Workers, and its 5 members who were dismissed back in 2016. On the other side is the respondent, an undeclared company. 2 key authorities are also central to this dispute: the Industrial Relations Department, which is handling the legal conciliation, and the employees providing fund, which is being pressured due to its investment in the company. The facts are straightforward but significant. In 2016, these 5 workers attend a union meeting. This meeting was peaceful, held outside of the working hours, and took place of the company premise. Following this, they were determined. The union filed a case with the JPP, arguing this was unfair dismissal and anti-union discrimination, and this conciliation process is still ongoing. Let's delve into the legal head of the matter. The first major issue is dismissal without just and reasonable reason under Section 20 of the Industrial Relations Act 1967. A worker has the authority to challenge a dismissal they believe is without just cause or excuse. In this scenario, the employer state reason attending a union meeting is highly questionable. It failed to meet the legal threshold for serious misconduct that would justify termination. However, the second, far more serious allegation is anti-union discrimination, commonly known as the union busting. This is governed by Section 59 of the same Act, which explicitly provides employers from dismissing, treating, or discriminating against an employee for being a union member or participating in lawful activities. The union's core argument is that the dismissal were a direct punishment for union participation, making this potential violation of Section 5. Moving beyond specific section of the Industrial Relations Act, the case also involves broader fundamental principles. The third issue is the violation of freedom of association. It is a constitutional right granted under Article 10 of the Federal Constitution. The act of dismissing employees for associating with their union strike at the very core of this democratic freedom. It's worth noting that even EPF own investment policy recognizes this principle. The fourth issue is the failure of natural justice procedures. It is the fundamental rule of common law that require procedural fairness in any decision affecting a person's right. It's mandated that before a dismissal, an employee must be given a proper notice of the allegation, a fair right to be heard in their own defense, and the benefit of an impartial investigation. There is no indication that the 5 workers here were granted any such fair hearing, which renders the dismissal procedurally defective and unjust. A court will be guided by 2 fundamental legal principles. First, the burden of the lies with the employer. Under Malaysian Industrial Relations Law, it is not for the employees to prove they were wrongfully dismissed. Instead, the employer bears the full responsibility of demonstrating to the court that the dismissal was justified by a fair reason, such as a genuine misconduct or poor performance, and that a proper and fair disciplinary procedure was followed. Second, union activities receive heightened legal protection. The specific allegation of anti-union discrimination under Section 59 of the Industrial Relations Act 1967 is critical. The court will examine this claim with particular care. If the employer cannot provide a strong, credible reason for the dismissal that is completely separate from the employee's participation in union activities, the court is very likely to declare the termination invalid and wrongful. Regarding the case progress, it remains in the chronological conciliation phase at the Industrial Relations Department (JPP). The standard resolution path is clear. If this mediation effort is unsuccessful, the next mandatory step is for the case to be referred to the Industrial Court. There, a full trial will be conducted, all evidence will be examined, and the legally binding award will be issued to finally resolve dispute.
My name is Priyashini. My metric number is 305693. I will now explain the solutions based on labor laws, common law, the code of conduct, and company policy. So I will cover 3 main solutions. For our first solution, we propose conciliation under the Industrial Relations Act 1967. Here, the company can call on the services of the Industrial Relations Department to begin the conciliation process. This enables both parties, the employer and the union, to negotiate and resolve the conflict without having to bring the case to the industrial court. This approach is important because it demonstrates good faith and adherence to the law. It shows that the employee is willing to cooperate and find a fair solution instead of escalating the dispute. The applied law here is clearly the IRA 1967 on conciliation and dispute resolution. From the article, we can see that the union complained of the claimed unfair dismissal of 5 employees, which makes conciliation the most acceptable first step. So, conciliation helps with both sides' communication, reduce tension, and aim for a win-to-win outcome. On to the second solution, which is to review the dismissal using natural justice. This means the company must determine whether the employees were given written notice, a proper investigation, and an opportunity to respond before being dismissed. By doing this, the employer ensures a procedurally fair dismissal. It also helps to minimize allegations of discrimination or victimization and give the employer extra legal power if the case is later referred to the industrial court. The applied law and court here are common law principles of natural justice and the company's code of conduct on fairness and transparency. From the article evidence, the protest makes a claim of unfair dismissal, which implies that there may have been a lack of proper procedure. So, this step is crucial to make sure the process was fair and aligned with both the law and company policy. Let's look into the third solution, which is restore the position with payback or provide monetary compensation. This means the company can either reinstate the employees to their jobs with back pay or offer financial compensation if reinstatement is not possible. This helps to reinstate the rights of the employees and solve the conflict in a cordial way. It also stops the dispute from increasing and helps to ensure harmony in the industry while showing the responsiveness of the employer towards employee rights. The law applied here is the IRA 1967 on remedies against unfair dismissal in compliance with the company's code of conduct obligations. From the article, it is clear that the union wanted the 5 employees back, which directly supports this solution. Overall, this solution focuses on fairness, restoration, and maintaining healthy industrial relations.
Hi everyone, my name is Nuteaiw and my lecture number is 305706. Next, I will talk about Employee Avenue for Resolution. This is about the ways employees can solve problems or seek justice at work. For example, if someone faces unfair treatment like unfair dismissal, they can first report it to their supervisor or HR. If that doesn't work, they can follow the company's grievance procedure or mediation to resolve this issue. As a last step, employees can approach external agencies like labor courts to protect their rights. These avenues make sure employees are treated fairly and the workplace stays safe and respectful. In this slide, I will explain the steps employees take when filing a complaint with the Industry Relations Department, or as known as IRD. As the first step is file a complaint. If employees feel they have been treated unfairly, like in the cases of unfair dismissal, they can make an official complaint to the IRD along with their unions. In the article we studied, the union has already done this, claiming that certain union members were being unfairly targeted. Filing the complaint starts the formal process of appealing against the employer action. As the second step is attend the conciliation meeting. Once the complaint is received, the IRD arranges conciliation meetings between the employer and the employee or union representative. These meetings provide a structured discussion aiming to reach an agreement without going to the court. This helps ensure that disputes are resolved fairly and professionally. Let's look what happens if the conciliation doesn't work. The third step is referral to the industrial court. If the dispute cannot be resolved through conciliation, the employee, usually with union support, can take the case to the industrial court. The court will decide if the dismissal was unfair and can grant remedies like reinstatement or compensation. Next step is internal grievance procedure if available. Some companies also have their own internal grievance procedure. Even though the article focuses on union action, using these internal channels helps document the issue and shows that employees try to resolve it within the organization before it's going to the external. The last step in Employee Avenue for Resolution is union action and collective measures. The article shows that the unions plays a key role in defending the employees. They protested publicly, submitted complaints, and represent workers' rights. Having union support strengthens the employee's position and ensures they are not facing the employer alone. These collective actions give employees more confidence and protections when addressing the unfair treatment.
My name is Nuteaiw and my metric number is 305274. And I'm going to talk about employers' preventive measures. There are 3 recommendations for the employer. First one is they have to respect union employee rights. The right to join or form a trade union is a legal right of employees. Employers must recognize legitimate union representation in line with labor laws and international standards like ILO Convention 98. Not only that, employers should avoid any form of intimidation and discrimination against union members. For the second recommendation, employers should ensure fair and transparent dismissal procedure. Where there is a legitimate ground for dismissal or disciplinary action, employers must follow due process. This includes conducting a fair investigation and upholding the principle of natural justice. Employers should avoid vague reasons like they are union members or because they are protested. The employer need to basing decision on proven misconduct, not on union membership or lawful union activities. For the last recommendation, foster a culture of respect and fair labor practices. Employer should promote awareness that union membership is lawful and encourage open communication and protect the whistleblowers from victimization and address union-related grievance promptly to prevent escalation into disputes, legal action, or reputational harm of the company.
In conclusion, this case highlights how the dismissal of 5 union members was carried out without just cause, violating both Malaysian labour laws and the constitutional right to freedom of association. The employer failed to prove a valid reason, making the dismissal disproportionate and discriminatory. This dispute showed the fragility of worker rights when enforcement is delayed, and the importance of union, external stockholders, and stronger legal mechanism in ensuring justice. Employers must learn to respect union rights, follow fair procedure, and engage in dialogue to maintain industrial harmony and prevent future disputes. That's all from me.